Oh, it says we're live now. All right, let me check.
Hi.
All right, I'm gonna double check just to make sure our viewers can see us.
Cindy,
Let's see.
Go on Eddie's page and see if Facebook, right? Facebook, yeah.
For everybody that's watching, oh, we are live. There we are. So
we are.
Hey, good morning, everybody. Here, Morning with Reyes, hanging out here with Ruby Wake from Wake Law LLC. She, you know what? I was seeing what she was doing. She was making some videos online, and she was talking about things that have to happen. You know, she does like estate planning and things like that. And I was like, man, I gotta have her on my show. And the reason why, because this is the best time. Listen, we're in a very unpredictable time at the moment. In fact, I mean, with this coronavirus issue and what's going on right now, we're getting, hundreds of thousands of people getting infected, and thousands of people are unfortunately are dying because of this. I know people close to me have, and I know Ruby, some people close to you as well. So estate planning is super, super important right now more than ever, in particular because of what's going on. So Ruby, tell me about yourself and tell me about why is this so important? And I mean, to me, it makes sense why it's so important, but explain the process of why somebody needs to get something done before, in the random event, something happens to them.
Yeah. So yeah, you nailed it right on the head, Ed, because right now, unfortunately, let me just back up. I am an estate planning attorney, which means I draft wills, powers of attorney, trust, health designations of healthcare surrogates, advance directives, guardianship nominations for clients. I also work in the probate field. So when someone does pass away, if they own assets in their individual name or and they do not have a beneficiary designation, we go through what's known as the probate process. And that's just basically us requesting to the court to have someone appointed as executor or personal representative of your estate. That way someone can be in charge of transferring assets from the person who passed away to the beneficiaries of the estate. And I also work in the elder law world, which means clients who are ready to go into a nursing home or an assisted living facility, for example, or can no longer take care of themselves, but they have some money, but not enough money to really pay $8,000 a month towards a nursing home. So I help clients qualify for Medicaid. So that's sort of what I do in a nutshell. So what I want to focus on and what I think is really prudent right now for our clients or for anyone who's watching this video is the importance of having some type of healthcare documents and estate planning documents in general in place now before you become sick. So unfortunately, I just shared with you, Ed, that we lost a very close and dear friend of ours this morning to the coronavirus. She was one of my mother's best friends for over 35 years. And she was my mom's age. She had 2 kids who were slated to start college this fall, and she passed away. And the worst part, what's sort of shaken us is that what people don't realize is that when you get a positive diagnosis and you are admitted to the hospital, you are secluded from everyone. So you don't get, you don't get to see your kids, you don't get to see your spouse or your loved ones. So she passed away by herself. I don't know her particular situation, and if she had estate planning in place, I'm sure I'm going to know about it within the next day or so. But so it's not that you get admitted to the hospital and all of a sudden, okay, now's the time for me to draft a will and a power of attorney and healthcare. That there is no time for that. You get taken away from your family, you get put into quarantine, and that's pretty much going to be your last communication with them. We as attorneys do not have the flexibility of doing online notarization like some states have. In July, we will have a law in place here in Florida. But until then, we are sort of at the mercy of our current law. And our current law says that we need 2 witnesses and for good measure, a notary public present when we sign estate planning documents. So if you don't have those documents in place prior to you getting admitted or prior to you becoming sick, your family is going to face a lot of financial hardships. So I want to take a minute, if it's okay with you, and just explain what documents should be in place. Now, yes, this is not meant to replace a detailed estate plan, but something that we can do quickly, that any attorney can do quickly for you. And in fact, at the end, I'm going to sort of roll out something that myself and a couple of other attorneys have been sort of working on for the past week to get back to our community. So I didn't even speak to you about it. But so
surprise.
The first document we should have in place is the power of attorney. So the power of attorney allows you to appoint someone to handle your financial affairs. So you think about who's going to pay your mortgage, who's going to write checks. But more importantly, if that person is also going to be able to apply for government assistance programs. So if you do need Medicaid, if you do need Social Security, if you do need to apply for a PPP loan, or you need, to speak to the IRS about your stimulus check, who's going to do that for you? My husband, even though he's my husband, cannot call up Medicaid and say, hey, Ruby's now disabled, she needs Medicaid, or Ruby's now disabled, she needs Social Security. My husband cannot do that. My parents cannot do that for me. No one can do it unless I appoint someone as attorney, in fact. So the power of attorney is a very useful document, but it's also a very dangerous document because, as you can imagine, Ed, you're giving someone a whole lot of power over your finances. So
now, can you make it limited? Can you make it like limited?
You could make it a limited, but then you're limited. So it's sort of is a double-edged sword. Yes, we can limit it to just real estate transaction or just banking transactions, but it's still dangerous. If I'm limiting it to just real estate transactions, that means someone can come in and sell my house. If I'm limiting it to just banking transactions, that means someone can still empty out my bank account. So I wouldn't suggest necessarily executing a limited power of attorney unless you're doing it for just one small particular purpose. But if you want a comprehensive power of attorney, just appoint someone that you trust. You trust, like I tell my clients, you have to trust them blindfolded with your hands tied behind your back. So someone that you trust and someone who's going to do right by you. Yes, whoever you do appoint, if they do end up stealing from you, there are legal repercussions, just the same way if I were to steal from you directly. But what we find in our world is that by the time we find out that the power of attorney was being misused, it's too late because the money's gone and you can't squeeze water out of a rock. So just appoint someone who you trust, who you know is going to sort of have your best interest at heart. Typically, that's a spouse. A lot of times we use siblings or even parents if they are of age to be up for that task. We don't want to appoint an 80 or 90-year-old parent. Not to say that there aren't 80-year-olds who can do it, because there are. But for the most part,
well, especially right now too.
Someone who is you're going to outlive, because the moment you die, that power of attorney dies with you.
Okay.
The documents right now that are really important are also the healthcare documents. So there are 5 healthcare documents that should be in place. I'm not going to discuss all of them. I'm just going to discuss the most important one, which is the designation of healthcare surrogate. And for my viewers up in New York, you would hear this called the healthcare proxy. Same difference. What it is you appoint someone to make medical decisions for you. So if, God forbid, you are on a ventilator, you cannot communicate your decisions. You are in a vegetative state, your brain dead. Think about Terry Schiavo, how she was in a coma for over 20 years and her parents refused to take her off of the ventilator and the artificial sort of nutrition and everything that kept her alive. So the designation of healthcare surrogate, you want to appoint someone who's going to uphold your wishes, no matter how difficult it may be for them. And what I mean by that is, I love my mother to death, and I know she loves me as well. But I know for a fact if I was in a coma and the doctor said, hey, Ruby is brain dead, there is no coming back from this, she'll still surround me by velas, and she'll still pray for my recovery and hope that I come out of it. I don't want that life for myself. And I know most people, absent some type of religious belief, wouldn't want to be in that sort of state. So whoever you appoint for your healthcare surrogate or healthcare proxy should be someone who's going to uphold those wishes, no matter how difficult it may be for them to sort of pull that plug, as they say, or make that. But in the coronavirus stage era, that's even more important than ever, because let's say you're separated from your spouse. Do you really want your soon-to-be ex-husband to determine what's in your best interest when it comes to your
No.
Exactly. And we get that a lot. We get those people who need that, who by default have someone who they don't want, or an estranged parent or an estranged sibling when you have relationships that with people who can actually will uphold your wishes and have your best interests at heart. So that's the designation of healthcare surrogate. And then for us, like yourself, Ed, that you have minor children, it's really, really important to have documents in place for those minor kids. So if you find yourself in a situation where you're admitted to the hospital and now your kid needs to go to the doctor or needs to have something done for them, whether it's registered at school or moved or done, you know, anything that we do as parents that we take for granted because we don't need legal authority to do so. A grandparent can't legally take a child to see the doctor. Now, most doctors will see you, but it's technically against the law for someone who isn't a parent to take a child to the doctor or take them out of school. Let's say you're admitted to the hospital for an extended period of time and your child, now it's a little different. I know we have virtual schooling, but under normal circumstances, imagine you're admitted to the hospital, your child needs to get picked up from school, or now they're staying with grandma and grandpa and they live across town, and it just makes sense for them to be registered in a different school. They don't have the ability to do that or the power to do that. Yeah. So what I have my clients do is a power of attorney and designation of healthcare surrogate for their minor children. So obviously, if we are here and able to make decisions for our kids, we should be the ones to make it, and we will be the ones to make it. But if we find ourselves in a position that we are admitted to the hospital or we are just unavailable to them for whatever reason, we have those documents in place to pass that torch to someone else and let someone else sort of step in our shoes. So a will is important. A trust is important, obviously. I'm not going to get into the importance of those documents. Obviously, they're the ones that are going to pass the wealth or whatever you worked hard your entire life to accrue down to your spouse or to your children, whatever the case is. But if you can have anything done during the coronavirus age that we're living in now, power of attorney, designation of healthcare surrogate or healthcare proxy, depending on the state you're living in, and nomination of those powers of attorney and healthcare surrogates for your minor children, if you have any at home. Biggest recommendation.
Let me ask you, because some people will still sit on the fence, you know, because they're like, it'll be all right, whatever. Does a will expire? That's one of the questions I have. And the second thing is, how difficult is it? Like, let's say they don't have a will. Let's say they didn't do nothing. They say, you know what, I don't care, it's gonna be all right. And they do pass away or whatever the case. How difficult is it going through the probate stage?
Okay, good question. So a will does not expire unless you revoke it or rip it up or do something. So I have probated wills that were drafted in the 40s and the 50s, which is not a good practice. So I always tell clients that these documents, any estate plan is they're living documents. And what I mean by that is that as your life changes, the documents should be upgraded and updated to reflect your current situation. So I have documents where they appointed, you know, their husband and then the siblings or their parents as executors or personal representatives, and they're all dead. So it's like almost like you did absolutely nothing. So it's really important that you find an estate planning attorney who's going to upgrade those documents on a year-to-year or 3 to 5 year basis. For my clients, all of my clients get the luxury of having complimentary updates on a year-to-year basis. Okay, so long as it's a simple change. If I'm changing, you know, I appointed Ed Reyes as my power of attorney and now I don't like you, I want to appoint you. That's a name switch. I'm not going to sit here and pretend that I drafted a whole new document for you when I didn't. It was just a name change. So our clients are able to update those, because I really do believe that a lot of clients do not update documents because they fear having to pay for that whole thing all over again. And it's logical. So instead, I sort of take that worry away from them and they're able to do it on their own. So now, but unfortunately for the ones who, a part of my process is avoiding probate. And how can we avoid probate? Why do we want to avoid probate is the main question. One, it's going to cost you your kids or your husband, whoever's inheriting your assets, 3% of the value of your estate. So if you die, you own your house in your individual name. The house is worth $200,000. And your kids want to probate that house, it's going to cost them at a bare minimum $6,000 just to probate the house.
Wow.
So it can be very expensive, and it goes upwards from that because that doesn't include, you know, your bank accounts and everything else you own. So 3% is a pretty hefty sort of price tag to pay, when I promise you a comprehensive estate plan will cost you half of that. So it's sort of like you're prepaying for the probate by seeing an estate planning attorney. Not only that, it's going to take your family about a year to a year and a half, some cases 2 years, to go through this whole process.
That's a long time, yeah.
Who's paying your mortgage? Who's paying for the keep on your house? If you have minor children, who's feeding your kids? Who's keeping everything going in your household while we go through this whole probate process? Never mind if there's a contest, if someone contested, then we're stuck in probate for years sometimes.
Well, and plus you want to get rid of this feeling, like, you know, somebody just died. You want to move on. You don't want to be dealing with this for so long. Closure, yeah.
Yep. And that's a big sort of issue that, you know, you can't put this to rest until you finish it. And Florida is a state that requires that you keep them. There are so many steps to it that you have to hire an attorney for a formal probate proceeding here in the state of Florida. Florida is not a do-it-yourself state. Like, I come from New York originally. In New York, we have a great do-it-yourself court system where even, you know, family law and probate courts, they have all of their forms listed online. As a layperson could go in, pull them out. There are very specific instructions. You can very easily do it yourself. Florida doesn't allow it. Florida requires that an attorney of record be put on there. So there is no way around paying that 3% legal fee. And then on top of it, to add sort of to add more to the whole reasons you don't want to go through probate, you're also opening up your estate to potential creditors. So the state of Florida feels that if you owe someone money, even though you're dead, you should still pay them back. And yes, you might have a moral obligation as a child, but you have no legal obligation. Like if my mother were to, God forbid, pass away, I have no legal obligation to pay her debt, but her estate does. So if we go through probate, we have to publish a notice in the local newspaper saying Ruby Wake passed away. If she owes you money, file a claim against her estate. And we have to keep the estate open for 3 whole months to allow creditors to trickle in. And you know for a fact that American Express, all of these, you know, banks, Capital One, they have people who just go through these legal notices that we all skip through. But there are departments who go through legal notices and say, oh, Ruby had an account at Capital One. Let's file a claim against the estate. So before my husband or my children are able to pay a penny out to the beneficiaries, they first have to pay those creditors. And 9 out of 10 times, I'm not too concerned with credit card debt. Most of the time I can settle that or, you know, negotiate it down. What I am more concerned about are those last hospital bills. You know, my smallest estate here, I'll tell you a quick story. My smallest estate was $15,000 estate. It was a personal injury case. He was hit by a car and he only received $15,000 because that was the policy limits. $5,000 went to the personal injury attorney. $2,500 went to me to probate the estate. $7,500 were left, and those $7,500, St. Joseph's put a $1.2 million lien against the estate.
Good Lord. Yeah. And we see that on our side quite a bit. We have to set up guardianships and stuff like that. I mean, it's pretty crazy. Like on our side, we see that it's important to have a will, and that's what we tell our clients too, because I mean, you just never know, especially these wrongful death cases that I get sometimes. A lot of people don't have a will, and then we're going through this process. And it's a long extended process too.
Yep. And you have to get court approval. You have to, you know, there's some things that we can avoid going through probate. Like if there is a wrongful death, there's nothing we can do. We have to go through probate for something like that. But if we can mitigate your exposure to creditors, the assets exposure to creditors, that's sort of, you know, then we're in a better place. If the only thing that they can grab onto is a lawsuit or something minimal, you know, we can settle that away. But if you have a house, you have bank accounts, you have life insurance, you have retirement accounts, and they're all going through probate, we can have a mess on our hands, and you can potentially inadvertently be disinheriting your children by going through the whole probate process. Wow,
look at that.
Yeah.
So how would somebody reach out to you and tell us about this program?
Oh, yes. So
anticipation.
Yeah, so a group of us, and everyone is going to roll it out on their Facebook page. I'm not going to sort of put anyone on blast right now, but a group of us attorneys sort of have gotten together and we thought about, what can we do like right now for our clients, or for not just our clients, for the community in general, to give back, to give some people a level of assurance that, if God forbid they do get trapped and they do get the coronavirus and now they're in the hospital, they have something in place for at least their families to feel a little bit better and a little more in control. So what we've decided to do, and we're going to roll it out. There'll be a link on my page soon. We are going to provide free healthcare designations of healthcare surrogates for everyone and anyone who signs up for it. I don't care if you're a millionaire or if you have $1 in the bank. I don't care what your circumstances are. I don't care if you already have estate planning documents, if you have no interest in estate planning documents. You can sign up and get that free designation of healthcare surrogate, which I normally charge $250 to prepare, and is going to be free for anyone who wants it. I cannot meet with them, so there's going to be a form that they complete, and I will give them execution instructions. All they need to gather is 2 witnesses, and it'll be a legally binding designation of healthcare surrogate. So at least they can appoint someone to make those end-of-life decisions or medical decisions, someone who's going to uphold their wishes, someone who has their best interest in heart. And that means that this person, if they feel that St. Joseph's is not doing right by them, they can move them to Tampa General Hospital. That's the power of the healthcare surrogate. So it's really, really important to have that in place. And we're going to we're giving them away for free. All you have to do is sign up, give me some information. Someone will be in touch and send them right over to you.
And also put, Ruby, in the comments, if people comment, just interact with them. But yeah, I'll share your information inside the comment, but also put your information as well. How can somebody reach you if they're watching it live right now?
So the easiest way to reach us now is just give us our call on the office. Our 800 number is not 800, but it's 833-WAKE-LAW. So that's 833-WAKE-LAW. Cool. Email is fine as well. It's just a little longer. It's rwake@wakelawllc.com.
Okay, perfect. So if everybody's sharing, people that are watching right now, feel free to share with other people as well. We'll be commenting throughout the day. We'll be sharing in different groups. So feel free, if you comment, she or I will get back to you, being that this is an estate planning webinar that we're pretty much doing. She'll be the one that mostly is commenting, but because I don't know, I need the personal injury side of it.
We play in different sandboxes.
Different sandboxes all day long. So thank you so much for your knowledge and for your expertise. And I think it's going to be a value to a lot of people that watch this video. And feel free to reach out to Ruby as well. Okay. All right.
Thank you so much for having me, and I really appreciate it. Have a good one.
All right. You too.